Good morning. Thank you very much for joining us for this interview, which is sponsored by the Jean Monnet Chair in Trade and Environmental Conflict. We have the great opportunity today to have a special guest, Professor Nicolas de Sadeleer. He is professor in European and Environmental Law at the St. Louis University and the Catholic University of Louvain.
Hello.
Good morning, Professor. Thank you for joining us. My first question to you would be, what is an environmental tax?
Well, an environmental tax aims at modifying the behavior of the consumer or the undertakings placing a product or a good upon the market with a view to enhancing the quality of the environment. Accordingly, an environmental tax does not have the classical redistributive function, but plays a much more incentivative function. So the best environmental tax are deemed to disappear at the end of the day on the account that the producers or the importers are likely to substitute the more hazardous products by less hazardous products.
So, Professor, does that mean that there is a risk that eco-taxation hinders the free movement of goods?
Indeed, as I already explained in former interviews, eco-taxation schemes are likely to run counter provisions of the Treaty on the Functioning of the European Union, such as Article 28 and 30 that are prohibiting custom duties or measures equivalent to custom duties, or Article 110 of the Treaty on the Functioning of the European Union that prohibits discriminations in the taxation area.
And does the fact that the national eco-tax complies with the 3D provision on the free movement of goods mean that they comply with the provision on state aid?
One has to bear in mind that Articles 28, 30 and 110 are aiming at preserving the free movement of goods, whereas Article 107 on state aids aims at preserving competition between undertakings by prohibiting the granting of state resources to companies. So whether a tax complies with the provisions regulating the free movement of goods does not mean that such a tax is lawful under Article 107 of the Treaty on the Functioning of the European Union.
Okay, thank you. Now, I do imagine that eco-taxation becomes very complex because of the distinction between different categories of goods and services. Could you please clarify?
Indeed, environmental law is rife with distinctions. So, regulatory approach does differentiate between goods, products, services, undertakings, according to the environmental impact. Accordingly, an undertaking impairing to a greater extent the state of the environment is likely to be regulated much more seriously than a small or medium-sized company whose impact is far less significant, you know. Accordingly, the tax arrangements developed by the state authorities, in particular with the view to curb the risk of climate change, do draw a number of distinctions between the undertakings according to their environmental impacts. Against this background was as to take into consideration that many tax arrangements provide for tax relief granted to specific categories of undertakings that do face strenuous competition at world level, such as steel mills. Why this tax relief provided for? Well, for the mere fact that these tax exemptions allow this undertaking to absorb the impact of these tax arrangements and allow these undertakings to remain competitive at a world stage.
Now, I do imagine that some eco-taxation may make the life of companies more complex.
Indeed, eco-taxation is likely to penalize companies polluting to a greater extent than undertakings whose impact is far less significant. So I imagine that eco-taxation is likely to reduce some economic opportunities. But in so doing, the tax authorities are aware of the risk of companies moving outside the country, outside the European Union. And so most of the eco-taxation schemes are quite progressive in nature.
Well, thank you. And do I have to consider this as an advantage after the discussions we've had in previous videos about state aid provided in Article 107 from the TFEU?
Yeah, whenever the third criterion regarding the selective nature of the tax is fulfilled, and whenever the three other criteria are fulfilled, one has to reach a conclusion that the tax exemption is a state aid. So the European Commission's, be it in its general block exemption regulation or be it in its environmental state aid guidelines, is taking the view that tax exemptions in the environmental field can be qualified as a state aid for the purposes of Article 107.
Now, Professor, could you give an example of an environmental tax fulfilling the criterion of selectivity?
By way of illustration, the Norwegian authorities have been developing tax arrangements regarding greenhouse gases emissions. In setting up these arrangements, they granted tax exemptions for the sake of companies producing or manufacturing goods, whereas companies producing services were falling within the scope of ambit of these tax arrangements. The EFTA court adjudicated that these tax arrangements were favoring certain categories of industries to the detriment of other categories of industries, and as a result, the criterion of selectivity was deemed to be fulfilled.
Does that mean the European Commission cannot take into consideration the aims or the causes of eco-taxation?
Indeed, Article 107 does not distinguish between state measures by reference to their causes or to their aims or their goals, but defines them in relation to their effects. So of importance is to pay heed on the effects of the tax arrangements instead of the goals these tax arrangements are achieving. So a tax arrangement which has the effect of conferring a selective advantage upon a specific sector or a specific product amounts to a state aid for the purposes of Article 107, no matter its genuine environmental objective.
Now, Professor, how does that work when there is an obligation in treaty law to take into account the environmental measures?
Indeed, Article 11 of the Treaty on the Functioning of the European Union, as well as Article 37 of the Charter of Human Rights, oblige the institution to integrate in all their actions and policies environmental requirements. However, the Court of Justice in the NOx Dutch case, as well as in a British aggregate case, took the view that Article 11 does not justify the exclusion of selective environmental tax arrangement from the scope of ambit of Article 107. So no matter the salience of the environmental objective of these tax arrangements, given that they are selective in nature, they are likely to fall within the scope of ambit of Article 107, to say the least.
And do you think the case law is likely to evolve?
No, British aggregates appears to be settled case law, so the General Court later on has been complying with that judgment, so I imagine that there won't be any change in the near future. As a result, the European Commission has to take into consideration exclusively the effects of the tax arrangements and cannot pay heed to the environmental objectives.
Thank you, Professor. So this was the end of the series on environmental state aid. If you'd like to obtain some more information, you can visit the website of the Jean Monnet Chair. Thank you. Bye.